Should Marjorie Taylor Greene be labeled an insurrectionist and then barred from Congress? Well, that's the question at the heart of a hearing that the Congresswoman testified in today over whether to block her from re-election. That due to her actions reportedly leading up to January 6th. The outcome of this case could actually have quite broad implications for other Republicans, including Donald Trump. But there was little lawyers could frankly get out of her today.
I don't remember. I do not remember. I'm sorry, I don't remember.
Well, I want to bring in John Bonifaz, who's the president of Free Speech for People, one advocacy group challenging Greene's candidacy. Listen, you saw she didn't remember a whole lot in those moments, she says. But we do remember, of course, there's Article, the 14th Amendment, Section 3, which is the primary basis for what's happening right now in terms of the collective memory of the U.S. about Civil War and those who were writing for the Confederates saying, we don't want you to be a part of Congress. That's the foundation of why this is even here. But as you know, the burden really is on those who are challenging her candidacy to prove that she, in fact, was the equivalent of, say, a member of the Confederacy back then in the Civil War. Have they made their case?
Well, Laura, thank you for having me. The voters of her district who have brought this challenge, and we're proud to represent them, have made a compelling case that Marjorie Taylor Greene, having taken the oath of office on January 3rd, 2021, then turned around and facilitated in the insurrection on January 6th. Now, the fact that she was incredibly evasive about not remembering tweets and statements and videos that she issued leading up to the insurrection is something the administrative law judge who held this hearing will have to factor into his decision. Was she credible in not remembering any of that? She even stated to the question that our co-counsel Andy Celli asked her as to whether or not she pressed former President Donald Trump to declare martial law to keep him in power. She said then, I don't remember. It's pretty unbelievable to consider that she does not remember whether or not she pressed Trump to declare martial law. Either the answer is no or yes, but it's not credible that she doesn't remember at all. So all of those claims of not remembering are going to have to factor into whether or not she was a credible witness today. But the tweets, the statements, the videos speak for themselves, and she engaged in insurrection.
Well, I'm curious about this because of the timing of it. And I know that you believe that they have made their case to at least challenge it. A lot of people are probably thinking, well, hold on, I've seen something like this before recently. Wasn't North Carolina? It had to do with another member of Congress, Madison Cawthorn. Why was that not where this case is now? What are the distinctions? Because we're not hearing from him in a trial or a hearing, are we?
We're not yet. We are proud to represent voters in his district as well, who are bringing this challenge to Madison Cawthorn for his role in the insurrection after taking an oath of office as well. But the reason why that case has not moved forward is because a federal district court judge, a Trump appointee, decided that he could interfere effectively with stopping the hearing from going forward in North Carolina before the State Board of Elections on the grounds that an 1872 amnesty law designed to provide amnesty to ex-Confederates after the Civil War from the mandate of Section 3 of the 14th Amendment, that amnesty law applies 150 years later to Madison Cawthorn. There is no constitutional scholar we've heard from who believes that that argument is correct, and it's contrary to the text and to the legislative history of the 14th Amendment and of the amnesty law of 1872. We have filed an expedited appeal with the U.S. Court of Appeals for the Fourth Circuit. They have granted our request for an expedited appeal, and that argument is being heard on May 3rd. And Madison Cawthorn may soon have to also face these kinds of questions.
Well, I'll tell you, I do recall at least one constitutional scholar talking about what you're talking about, and that was during the second impeachment hearing. I believe it was the House impeachment manager, Jamie Raskin, trying to make similar arguments. We'll have to see what happens. And speaking of January 6th, you know, it may have been useful, of course, for the January 6th committee to have had some public hearings to buttress the evidence that you are seeking to put forth in court. John Bonifaz, thank you so much for your time.
Thank you.